My dear colleagues in legal profession, my friends and fellow citizens, today I would like to reflect on a very disturbing question. What happens when the state takes away a citizen's liberty without justification? In the context of the Sonam Wangchuk case, liberty, accountability, and this particular case reference. My friends, the detention of climate activist Sonam Wangchuk under the National Security Act 1980 and his release recently raises precisely this question. What is the question? What happens when the state takes away a citizen's liberty without justification? Preventive detention laws allow the government to imprison individuals without trial. These laws are extraordinary powers that must be used only in the rarest situations involving genuine threats to the national security. But when such laws are used against peaceful activists, society must ask, is this about security or about silencing dissent? A habeas corpus petition was filed before the Supreme Court of India challenging the legality of this detention. Just before the court could examine the case and give its verdict, the government revoked the detention order and released him. Yes, the law allows revocation, but we must ask a deeper question. Why release him just before the court rule on the legality of the detention? Is it to avoid judicial scrutiny? History teaches that liberty cannot be protected without strong courts. In Rudal Shah's 1976 case, the Honorable Supreme Court awarded compensation for illegal detention. Then in Bhim Singh case 1985, the court held that the state accountable for abusing its power. And after the shameful judgment in ADM Jabalpur during the emergency in 1976, our Honorable Supreme Court later acknowledged that denying a habeas corpus was a grave mistake. And in case of Justice K.S. Puttaswamy and Union of India, these precedents remind us that the personal liberty is the cornerstone of the constitutional democracy. Today, my friends, preventive detention laws are increasingly used against the social activists, the journalists, and political dissenters. We have seen this in case of involving Dr. Kafil Khan, Dalit activist Chandrasekhar Azad, journalist Kishore Chandra Wangchuk, and others. If such powers are used casually, the consequences are dangerous. If the detention of Sonam Wangchuk was unjustified, then his release alone is not enough, my friends. There must be accountability, there must be compensation, and there must be clear guidelines to prevent misuse of preventive detention laws. A democracy cannot survive if dissent is treated as a security threat. My friends, therefore, the Supreme Court must ensure three things. First, it must examine whether the detention was lawful, because now the government has released him. The petition filed by him before the Honorable Supreme Court may become fractious, and on that pretext, the Honorable Supreme Court should not close the case. So, secondly, if it was unlawful, victim must receive meaningful compensation. Third, the court must lay down clear guidelines to prevent misuse of preventive detention laws, because liberty once lost cannot simply be forgotten. My friends, the Constitution of India is not merely a legal document. It is a promise that the state will never exercise power without responsibility and arbitrarily. The Constitution does not merely grant rights, my friends, it demands responsibility from those who wield power. The Honorable Supreme Court now has an opportunity to reaffirm the powerful principle: no government is above the Constitution, and liberty once violated must never be treated as a trivial matter. The Sonam Wangchuk case is therefore not just about one individual, it is about the future of the liberty in our democracy. Thank you. Thank you, my friends.